Good afternoon, everyone, or good morning if it's still morning in your neck of the woods, and welcome. My name is Alex Lucifero. I am the managing partner of Samfiru, Tumarkin, LLP's Ottawa office. We are the employment lawyers. This is employment law Q&A. Q&A for this Thursday afternoon. It's an opportunity for you to ask your questions about any employment-related issues that you're having at work. It's also your opportunity to ask about any disability insurance questions that you have. And oftentimes employment issues and medical leaves or disability insurance issues are all tied together. And so if you have any questions in that respect, if you're dealing with a problem at work, if you've been let go from your job, if you're dealing with a vaccination mandate issue, or really any issue under the sun when we're talking about the workplace, when we're talking about your work, if you have a question about vacation pay or overtime pay or sick leave, anything of the sort, this is your opportunity. Go ahead and ask your question online. I will answer it for you, point you in the right direction, give you the information that you need to resolve your workplace problem. This is that opportunity. We've got half an hour here to help resolve your workplace problems. Before I get into a couple of topics I wanted to touch on today, let me share some pieces of contact information. If you're maybe a little too shy, a little too bashful to ask your question online, and please feel free to. But that said, if it's maybe a little more complicated than just posting a question, go ahead and contact us off air. Of course, you can reach us at the office. The easiest way to get a hold of us is through our website, employmentlawyer.ca. Employmentlawyer.ca. You see it on your screen right now. Go to our website. It's got all of our contact information there. You can reach us very easily through the website. We also have a ton of resources. If you want to start with some very basic, very preliminary research, go to our website, visit a couple of the links, and we will get you pointed in the right direction. And then reach out to us. Send us an email or contact us through the website. Go ahead and contact us. That initial contact is free. We have an entire intake team that fields calls and fields questions all day. Don't be shy to reach out to us. Guys, there is no bad question when it comes to employment law. If you want to contact us by email, I'll give you our email address as well. The email address is help@employmentlawyer.ca, help@employmentlawyer.ca. Go ahead and send us an email at that email address. Give us a brief description of the situation you're dealing with, and I promise someone will get back to you. Leave us your phone number as well so that we can contact you over the phone. It's oftentimes easier, and I promise someone will get back to you and again put you in touch with an employment lawyer, with the person that you need in order to resolve your situation. Those are the main ways in which you can reach us, guys. And so if you'd like to ask your question right now, again, this is a live employment law Q&A, and we're also tackling disability insurance questions. If you're in receipt of disability insurance from an insurance company, you've been injured or you're ill, and you're off of work on a medical leave of absence, and the insurance company is giving you a hard time, perhaps they're questioning your doctor's opinion, or they're questioning what you can and can't do. Again, don't be shy to reach out with those kinds of questions. Oftentimes, it's unfortunately the case, we see insurance companies deny coverage, deny insurance, medical disability benefits all the time, and wrongfully so, where an employee is actually unable to work. An insurer will take the position that they're able to work, or that for some technicality, they haven't been approved for their disability benefits. And almost always, those decisions are incorrect and ultimately illegal. Before I get to the questions today, guys, and please go ahead and post your questions right now. Let's line up a couple of questions so that we can get going here. But before that, I did want to talk about one particular matter that was in the news very recently. We actually posted about it not too long ago, and it's actually a great example of a situation where an employee is going to be owed severance despite what's a very difficult situation. So this story actually comes out of California. Again, it was in the news recently. A gentleman was let go from his job at a gas station for making a very, very costly mistake. And this gentleman actually admitted his mistake very openly and honestly, as one should. What actually happened is this guy was operating a gas station for, I believe, Shell was the service station, and this gentleman put the decimal point for the price of gas in the wrong location. And what it meant is that instead of selling gas at $6.99 per gallon, $6.99 per gallon, this gentleman's mistake led to gas being sold at 69 cents per gallon. Obviously, a huge discrepancy, a huge mistake. And until this mistake was caught, I believe a few hours or some hours later, this mistake on the part of this particular employee had cost the company $16,000, $16,000. Obviously, a very costly mistake. Now, that said, this gentleman was very upfront about it. He immediately reported this to his employer. Didn't try and hide the fact that it was a mistake on his part. And unfortunately, ultimately, this gentleman was let go from his job. And the question that arose in this context is an employee in this circumstance, even if they've made a fairly serious mistake that cost the company thousands of dollars, does the employee have the right to receive a severance package? Does an employee who makes a significant error, right, and a legitimate error, so this is not something that was done vindictively or on purpose, right? This was a kind of good faith error where it was a simple mistake. Is that employee owed severance when they are let go? And so I wanted to touch on 2 points here, only because I answer these kinds of questions all day, every day. And so for those of you tuning in right now, hopefully you don't find yourself in a situation where you've been let go from your job for whatever the reason. But if you do, here are a couple of very key points that you should be keeping in mind when it comes to termination and when it comes to severance. The first point that should be made is in Ontario, and this is true generally in Canada as well, an employer can always let an employee go without cause. And I'm talking particularly here about non-unionized employees. An employer doesn't necessarily need to have a reason to let an employee go. An employer can let an employee go perhaps because things aren't working out as they thought they would. Perhaps it's not the right fit for that particular employer. Perhaps the employer has decided to restructure. It's also possible that an employee can get let go because the employer doesn't like that particular employee. Ultimately, the reason for termination does not matter. It is an inherent right that an employer has to let an employee go. Now, that said, an employee who is let go in those circumstances is owed severance. They are owed severance based on their age, position, and years of service. Now, in this gentleman's situation, let's say an employee makes a serious error at work. If it's the case that this employee, again, who's made a very serious error and cost the company tens of thousands of dollars, if that employee otherwise has a clean record of employment, they have no previous write-ups, they have no previous reprimands, let's say their performance has been solid throughout, and they're a relatively long-term employee, even if it's just for a few years, an incident like that is not enough for the employer to terminate that employee without severance. And so again, an employer has the right to let an employee like that go, but that employee, even if their performance isn't great, even if they made a serious mistake, if it was just a one-off mistake, that employee would still be owed severance. Keep that in mind moving forward. If ever you find yourself in a situation where you are being accused of some sort of wrongdoing, or your employer is letting you go based on a reason that you might feel is unfair, ultimately the legal recourse in the majority of cases is going to come down to severance. And unfortunately, what we also see in these circumstances is almost always an employer will make an inadequate severance offer. Employers will make the bare minimum offer that they have to make in the circumstances, hoping that the employee accepts whatever severance is on offer. And oftentimes that severance is deficient by a huge, huge margin. If you have been let go in your employment and you're staring at termination documents and you're being asked to sign off on an offer, do not sign without consulting with an employment lawyer. Please give us a call, send us an email, contact us online, however you want to get a hold of us. Send us a courier pigeon if that's easier. Please make sure you get your severance package reviewed by an employment lawyer before accepting a severance offer, whatever the circumstances of the termination are, whether you've been accused of something or not. You can be the best employee in the world, you can be the worst employee in the world. When you're made a severance offer, you need to have it reviewed by an employment lawyer, even if in the circumstances you feel a particular way about the termination. In this gentleman's case, again, where he made a fairly serious error, and for those of you just tuning in, we're talking about the story where a gas station employee changed the price accidentally of the price of gas, costing the company to the tune of about $16,000. Even in a case like that, in Ontario, in Canada, an employee would be owed severance, and an employee's severance entitlements aren't just a week or two per year of service. They're going to be significant. It's going to be several months. It could be as much as 24 months of pay for longer service employees. All right, guys, I wanted to touch on that again because it was an interesting story, employment-related story that came out of the news, and it provided a couple of good lessons for our viewers and for employees and employers, for that matter, as well. Terminations are always tricky. Make sure you get advice from an employment lawyer, whether you're an employer looking to terminate an employee or whether you're an employee who has been terminated. Before you sign off on anything, make sure you speak with an employment lawyer. And again, don't be shy to give us a call if you find yourself in that situation. Okay, I have rambled on for enough, everyone. Time to get to the meat and bones of the live segment today, and that is the questions. Thank you so much, everybody, for asking your questions. I have a good number here that I'm going to get through in order of priority here. And so Rocket was the first one. Rocket, thank you for your question on YouTube, who asks, can an employer make unreasonable changes that are arguably legal but can be uncomfortable to employees, such as moving you from an office that has an AC to an office that does not have an AC just because? Why not? Interesting question, Rocket, because I think there are a couple of points there to be made that are perhaps on kind of different sides of the equation here. So, first part of your question, can an employer make unreasonable changes that are arguably legal? So keep in mind, an employer is actually not allowed to make significant or substantial changes to the terms of your employment. An employer actually needs an employee's consent in order to do so. An employer cannot force a significant change on an employee when we're talking about pay, certainly also when we're talking about hours of work or conditions of work or your position, the type of job duties that you have. Any substantial or significant change can be considered what's called a constructive dismissal. A constructive dismissal in the employment context is basically a breach of contract. So what the employee is arguing here effectively is that you have changed the terms of employment so much that you have effectively broken the implied contract of employment between an employee and an employer. And so again, when we're talking about things like demotions from one position to another, let's say you're a supervisory employee and for no good reason, you're being demoted to some sort of laborer or some sort of general employee that doesn't have any supervisory duties, that is going to be a constructive dismissal. If an employer is trying to change your pay structure, if you are, if they're cutting your hours from 40 hours a week to 30 hours a week, that's going to be considered a constructive dismissal. That allows you to basically resist the change. And if the employer doesn't back down, you can ask for a severance package. You would be owed a severance package in a situation like that. Now, Rocket, to the second portion of your question, listen, I do have to say in all objective honesty, whether or not an employee has air conditioning in a particular office may not rise to the level of a significant or a substantial change. So again, there is a threshold there where an employer is allowed to make minor changes to the terms of your employment. And if they're relatively insignificant, then again, an employer would be allowed to do that. I'll give you a small example that's not related to AC. For example, if you work a regular 9 to 5 shift every single day, and your employer asks you to change that from 9 to 5 to, let's say, 8:30 to 4:30, a half an hour change in your schedule may not be significant enough to warrant a constructive dismissal. It doesn't rise to that level of breach of contract. The only way, Rocket, I can see AC in an office or not having an AC in an office being an issue is if it poses a health and safety risk. So if it is wherever you're located, if it is so hot or so humid that actually not having AC in an office is not only just a little uncomfortable, but it can actually potentially cause a health and safety concern, that might be a legitimate claim for a constructive dismissal. Keep in mind on this particular point that an employer does have a legal obligation to maintain certain health and safety standards in the workplace. You have the right as an employee to work in a safe work environment. If it is too hot, and we see this, for example, for farm workers, right, or employees that work in factories. If it is an unsafe work environment, if it is too hot or too cold for that matter, and that is starting to pose health concerns for employees, that would give you the grounds to say, hold on a sec here, I'm actually not going to work in this environment until you fix this issue. You have the right as an employee to demand that your health and safety rights in the workplace be respected. If that's the case, speak to your employer about it. If your employer is not willing to have that kind of conversation, go to, for example, in Ontario, we would have the Ministry of Labor that you can bring health and safety concerns to. They may appoint an investigator to actually investigate a health and safety issue and make a determination. Rocket, great question. Hopefully that provides you with some guidance and points you in the right direction. I will move on to Layla. Layla asks, while on maternity leave, my colleagues were given a bonus for the year prior. I worked during that time, yet was not given compensation for it. Is this right? Straightforward question, Layla, and no, it's not right. If you were actively working the year that the bonus was earned, so you actually worked for the bonus that year, you should be paid that bonus regardless of the fact that you went on maternity leave, or even if it was a gentleman and they were on parental leave. If you worked and earned that bonus, regardless of what kind of leave it is, you have a right to receive that bonus. Layla, if you haven't been paid that bonus and your colleagues have, that is a problem. You are owed that bonus. If your employer refuses to pay you the bonus, that might be discrimination under the Human Rights Code, and you might have a further claim in that respect. I would approach my employer about this, Layla. If your employer knows what it's doing, they will very quickly pay it to you if they haven't already. If your employer refuses to pay it, give us a call, contact us, go to our website, employmentlawyer.ca, find our contact information, send us an email, and I promise someone will be in touch. We have a saying, we've said this on the radio show for many, many years. We say it on the TV show as well. The saying is, don't mess with mama, and don't mess with dad either if they're on a parental leave. Employees have very strong protections, particularly for maternity and parental leaves. They have the right to go back to their same position. They have job protection. And in this case, Leila, you have the right to the bonus that you earned, regardless of the fact that you're on maternity leave. Don't mess with mama is the saying that applies, especially in a case like this. Appreciate the question. Simeon asks, with the suspension of the federal mandates for federal employees on June 20th, if my employer calls me to return to work, what are my legal options? Simeon, it depends very specifically on what kind of employee you are. If you're employed by the federal public service, if you're an employee of the federal government in Canada, you are unionized. Your rights and obligations will be determined by your collective agreement and what your union ultimately says. For the majority, I think for nearly the entirety of federal government employees, again, these are employees that work for the federal government, you have the obligation to return back to work if you're recalled. You're not owed any compensation beyond that, unfortunately. Now, and this is where things get interesting, if you're not a federal government employee, but your employment is federally regulated. So in Canada, what this means is certain types of employers and industries are federally regulated. The vast majority of workplaces are provincially regulated. Federally regulated employers are effectively employers in the banking industry, in the telecommunications industry, in the cross-border transportation industry, and there are a couple of others as well. Airlines, for example, any kind of transportation that goes across either provincial borders or international borders. And again, there are a couple of others as well, but those are the vast majority of those particular kinds of employers. And again, these employers are federally regulated, meaning they fall under the Canada Labor Code rather than a provincial employment legislation. For employees in either the banking or telecommunications sector, there was actually, and this is a bit of a misunderstanding that lots of employees have, there was actually no federal vaccine mandate to begin with. The government never came out with a vaccine mandate for, again, employees in the banking and telecommunications industries. There was a mandate, however, for the transportation industry. So if you work for a trucking company that crosses borders, again, either provincially or internationally, or if you worked for an airline, there was an actual government mandate in place with respect to the COVID-19 vaccine, rather, and that limits, again, the options that you have. Because it was a law, effectively, your employer is bound to follow those rules, and that leaves you, the employee, with very little recourse against your employer because they're simply following the law. However, for employees, as I mentioned, in the banking industry or in the telecommunications industry, again, there was no vaccine mandate in place, which means that if your employer imposed a vaccine mandate on you, if they put you on an unpaid leave of absence, or if they terminated your employment because you were not vaccinated, you have rights, you have protections in a case like that. Again, because your employer effectively did this of their own accord. They weren't following a federal government mandate. There was no mandate for the banking industry and for the telecommunications industry. And so in situations, again, if you work for a bank or if you work for a telecommunications company, an unpaid leave can actually be considered a constructive dismissal. You would be owed severance in a case like that. And so you do have rights, you do have options. It depends on your particular kind of work, and it depends on whether you are unionized or not. If you find yourself in a situation where you've been terminated and you are a non-unionized employee, go ahead and if you want to know how much severance you're owed, visit pocketemploymentlawyer.ca. It's the link on the screen or the address on the screen right now. It can give you a very good sense of how much severance you are owed. And even if that situation is related to a vaccination policy, and you've been put on unpaid leave of absence or you've been terminated, again, if you're a non-unionized employee and there was no government mandate in place with respect to vaccination, you are going to be owed severance. Don't walk away from a situation like that. You could be walking away from tens and tens of thousands of dollars. All right, Lisa, in a similar vein, and Lisa, I'll be quick here because I believe I already answered this question, but she asks, how will the recent announcement by the federal government to suspend vaccine mandates for travel and federal workers affect private sector employers who continue to cling on to vaccine mandates for their workplaces? Lisa, great question. And as I was just previously mentioning, again, as a refresher and reminder to those of you perhaps just tuning in, if you work for an employer in an industry where there was no government mandate in place with respect to the COVID-19 vaccine, provincially, there was really only one sector in which a mandate existed, and that was long-term care homes. If you are provincially regulated in your employment and you didn't work for a long-term care home, it is quite arguable that you would be owed severance if you were let go from your job as a result of your vaccination status, or alternatively, if you were put on unpaid leave as a result of your vaccination status. At the federal level, again, if you worked for a transportation company, so again, that could be ground transportation as far as trucking goes, or in airlines, and again, you were federally regulated, meaning you were going across either provincial or international borders, a mandate did exist. And that does limit the rights and options you have as an employee. You certainly have a right to return back to work as of June 20th when the mandates lift. And by the way, if you're let go, if you're not called back to work after June 20th and you're in that situation, well, guess what? You've been let go like any other employee has been let go, and you are owed severance as a result. Hopefully that answers your question, Lisa. And again, vaccine mandates have been the hot topic of the day in the employment law world for the past 8 months or so. If you are dealing with a vaccination issue, if you've been put on unpaid leave, or if you've been let go of your job as a result of a vaccination policy, and you are a non-unionized employee, don't be shy to give us a call or send us an email. Let's have a chat offline. Let's talk about your particular situation. Every situation is different, and so you need tailored advice in order to know where you stand and what options you have. You may very well have options in your situation, despite what you might believe. All right, Steve asks, employer said I was temporarily laid off in April 2020, called back in July of 2020 on a reduced 3-day per week. If provincially regulated workplace, what are my rights before and after IDL expires, if any? Steve, I think your rights might flow back to that July 2020 date that you were recalled. When you were recalled back to work at that time, do keep in mind that you had a right to be recalled back to work on the same terms of employment that you left. So if you were a full-time employee at the time, you had the right to be recalled to those full-time hours. That was the case then. Now, if you were happy to accept the 3-day a week call back to work, that's fine. If you agreed to the change, that's okay. But you had that right to effectively stand your ground and say, no, I want to come back to the same terms of employment that I left. Steve, the balance of your question really depends on your current status as an employee. So if that 3-day per week has continued up until now, your options may be limited. Simply because you've effectively accepted that change to your employment by working for that period of time. And really the IDEL, which is the infectious disease emergency leave, doesn't particularly apply to your situation. Steve, if you have any questions about your particular situation, or if things have changed more recently, for example, if you've been put on leave again, or if your employer has made further changes to the terms of your employment and their recent changes, do not be shy to reach out and let's have a chat. Again, employment laws in Ontario and across Canada are actually quite favorable to employees. They're quite friendly to employees. And so you may have further rights and further options than you actually think in your circumstances. For example, when it comes to temporary layoffs, do keep in mind an employer doesn't necessarily have the right to temporarily lay off an employee. You have to agree to that change as a term of your employment, and you don't have to agree as an employee to a temporary layoff. You can actually fight a temporary layoff and seek severance. So don't just take an employer's word for it when they make a significant change to the terms of your employment. Make sure you get legal advice in the circumstances. All right, guys, a couple of questions, which I will squeeze in the next couple of minutes. We've got about 3 minutes left here. Stephanie asks, we've recently proceeded with a demand letter to my husband's company for being laid off. Long story short, just wondering if his company owes him severance. This is a proven fact that was checked by a lawyer. How likely are employers willing to drag something to court? They truly believe that they don't owe him anything because he was a construction worker. Stephanie, great question. The reference to construction worker is one that we often hear and is a misconception in employment law. Almost certainly, if not certainly, despite the fact that somebody works in construction, they're going to be owed severance. That is an established fact. Now, if you're dealing with a temporary layoff situation, you referred to a layoff. I'm not sure whether you're talking about a temporary layoff or a permanent layoff. If it's a permanent layoff, listen, your husband is owed severance. There's going to be no question about it. It simply becomes a question of how aggressive do you need to be in order to ultimately get the company to pay. Some employers are very reasonable and pay very easily and quickly. Other employers are very stubborn and, dare I say it, very cheap. And so it requires more aggressive action, and that's okay. That sometimes happens too. It just means you have to be patient and persevere a little more. If this is a temporary layoff, Stephanie, if this is the first time your husband has ever been laid off before, and layoffs are not a term of his employment, then you are still allowed to seek severance. If, however, he was, for example, a seasonal employee and he was laid off year in and year out, well, that is an implied term of employment, and he would not be able to pursue severance there. Hopefully that points you in the right direction, and certainly you should have been having these kinds of conversations with your lawyer. if you've already engaged one. All right, last question of the day, folks. Dom asks, if I fulfill requirements to keep a professional license active, but the administration made an assumption I did not and reported to regulatory body by terminating my representation for the company. I've since made the admin aware that I fulfilled the requirements to keep my profession, but the admin is not doing anything to reinstate my representation for the company. Now regulatory body is asking. Dom, it sounds like there was a breakdown in communication there. It ultimately is going to come down to who is responsible there and where the liability lies. If you did what you had to do on your end in fulfilling the requirements and making sure that you were properly licensed, and your employer made an administrative mistake, the responsibility is going to fall on them. If you live in Ontario, if you live in Canada, and that has resulted in the termination of your employment, you are going to be owed severance, and you may even be owed additional damages beyond that due to the error that they made. Hopefully you can get your job back in this situation if this is just an administrative error. But again, it depends where the liability lies. If your employer made the mistake on its end, you are owed compensation as a result if you're not owed your job back fully. I will leave it at that, guys. Thank you so much for your questions. Unfortunately, we're out of time, but don't fret if I didn't get to your question today. Tune in tomorrow. We're here for another edition of Employment Law Q&A, going to be live. Please ask your question there. Thank you all so much for joining us. Have yourselves a great rest of the work week and a great weekend. We will catch you here next time. Until then, take care, everyone.